Welcome back, finance fans. Let us begin this second segment with trading ahead of the customer. Trading ahead of customer orders, limit order protection rule. A broker-dealer violates FINRA rules if the firm accepts and holds a customer order for an equity security and executes a trade involving that security for its own account at the same price and on the same side of the market, buy or sell. For example, if a customer places an order with her broker to buy 1,000 shares of AME at $35 per share, and while holding this order, the firm buys 1,000 shares of AME at $35 for its own account, it has an obligation, within 60 seconds, to fill the customer's buy order at $35 or better. An exception is granted if the firm has different departments that traded the same security under certain conditions. In the previous example, if the department that purchased the shares of AME at $35 is different from the department holding the customer's order is not required to be executed. However, the two departments must have appropriate information barriers in place for this exception to apply, quoting a security in multiple mediums. In some circumstances, a broker-dealer may want to display a quote for the same security in more than one market. FINRA permits a firm to engage in this practice, but requires the same price to be displayed. For instance, if a firm has placed an offer to sell stock at $20 per share in one market and wants to enter another offer for that same stock in another market, the offer to sell must also be $20 per share. Mutual fund trading rules. Under certain conditions, a mutual fund is allowed to buy securities from and/or sell securities to another mutual fund without being subject to trading restrictions. Rules 17A6 and 178A7 of the Investment Company Act of 1940 provide an exemption if the transactions are deemed minor and occur strictly between portfolio affiliates or between an investment company and certain affiliate persons. For example, a mutual fund can purchase securities from another mutual fund if both funds are controlled by the same investment company. Insider trading. Sections 10b5-1 and 10b5-2 of the Securities Exchange Act of 1934 are the most important rules related to insider trading. Insider trading involves the purchase or sale of securities using material, non-public information about those securities in a fraudulent manner. Material, non-public information is defined as information that, if made public, would likely affect stock or bond prices. The fraud typically involves either the misuse of confidential information by a person who has a fiduciary duty to shareholders or the misappropriation of confidential information obtained from an employer. It is important to note that trading by a firm or individual based on information regarding a large client's potential buying or selling does not constitute insider trading. This prohibited practice is referred to as front-running. If a corporation possesses material information, it must release it to the public before any person may use the information to complete a transaction. Releasing the information only to broker-dealers, financial analysts, shareholders, or any other limited group is prohibited. One way information is considered to have been released publicly is if it is provided to the financial news media. Once provided, the media will have the opportunity to disseminate it. Tippers and tippies. In some situations, material, non-public information is passed from one person, the tipper, to another, the tippee. The tippee then trades on the information. If the tippee knew, or should have known, that the information was confidential, both the tippee and the tipper may have violated insider trading rules. For instance, assume a member of a corporation's board of directors tips a relative about a pending takeover involving the corporation. If the relative trades on the information, this is likely a violation of the Exchange Act. Another example is when an investment banker is working on a deal with a company and then informs a trader. Ultimately, a broker-dealer is responsible for the actions of its representatives, even if the broker-dealer doesn't use the information to trade for its own account. Insider trading legislation. Over the years, several high-profile cases have brought significant congressional interest in insider trading. Since some of these cases involve broker-dealer employees, the Insider Trading Sanctions Act of 1984, ITSA, and the Insider Trading and Securities Fraud Enforcement Act of 1988, ITSFEA, were enacted in response. The ITSVA required broker-dealers to establish, maintain, and enforce written policies and procedures that are reasonably designed to prevent the misuse of material, non-public information. The ITFVA stipulates that anyone who purchases or sells a security while in possession of material, non-public information, or who has communicated such information to another party in connection with a transaction may be liable. Broker-dealers must not only create such written policies, but they must also ensure proper implementation. A broker-dealer with a comprehensive system of procedures to prevent insider trading may still face SEC penalties. These procedures should include several key elements, such as a system for monitoring employees, personal trading and trading in firm proprietary accounts, restrictions or monitoring of securities trading where the firm has access to insider information, procedures to limit access to files containing confidential information, including the establishment of information barriers, education for employees regarding insider trading issues. An information barrier consists of a set of procedures that prevent the transmission of confidential information from one department to another. Information barriers were previously referred to as Chinese walls. These barriers can be both physical and procedural. For firms that hold confidential information, the importance of implementing effective information barrier procedures cannot be overstated. The SEC has not mandated a specific system to accommodate the varying operations of different broker-dealers. However, this also means that there is no safe harbor for a firm's information barrier procedures. The responsibility lies with the firm to demonstrate that its procedures are sufficient. Only firms engaged in investment banking, research, or arbitrage activities are required to maintain restricted and watch lists. However, these firms must have written procedures addressing the use of material, non-public information by their employees. The restricted and watch lists include securities that employees are either restricted or prohibited from trading. The restrictions or limitations associated with these lists apply to employee transactions as well as solicited transactions with customers. The restricted list must be shared with employees. However, the contents of the watch list are typically known only to select members of the legal and compliance departments. The firm's written supervisory procedures should describe when and why securities have been added or removed from the lists. The restricted and watch lists should identify the contact person who added or removed the security. However, providing the rationale for the decision is not required. If a securities professional acquires material, non-public information about a company, the best course of action is to promptly notify their compliance department. At that point, the compliance department can place the issue on the firm's watch list. Violations of insider trading rules by broker-dealer employees can lead to severe consequences for both the individual and the firm. Insider trading violations can result in civil penalties up to 3 times the amount gained or loss avoided in the transactions. The SEC may also require disgorgement of profits, meaning the insider trader may be obligated to return any profits earned. Any person who oversees the violator may face civil penalties not exceeding the greater of $1 million or 3 times the profit gained or loss avoided. The ITSV has significantly increased the criminal penalties for violations of the Exchange Act, including insider trading. An individual may face fines of up to $5 million or imprisonment for up to 20 years. Per violations and other non-natural persons may incur fines of up to $25 million per violation. The Department of Justice is responsible for criminal actions. The Act also permits the granting of bounties for information that leads to the payment of penalties associated with insider trading violations. The SEC has the authority to determine the bounty amount. However, it may range from 10% to 30% of the money collected. Other prohibited activities. The new issue rule. New issues, e.g. IPOs, can dramatically increase in price shortly after entering the aftermarket. Under the FINRA rule, titled Restrictions Preventing Associated Persons from Buying IPOs, the new issue rule, a brokerage firm must make a bona fide offering of new issues to the public and must not withhold any shares for its own account, employee accounts, or accounts of other industry insiders. The rule also prohibits FINRA member broker-dealers from selling a new issue to accounts where a restricted person holds a beneficial interest. Nevertheless, an exemption exists that permits personnel of a limited broker-dealer to purchase shares of a new issue. A limited broker-dealer confines its business to investment companies, variable contract securities, or direct participation programs. For instance, a registered representative employed by a firm that exclusively sells mutual fund shares is exempt from this rule. The rule contains definitions of key terms, several exemptions, and an obligation for the broker-dealer to obtain a representation from the account holder confirming their eligibility to purchase new issues. Please take note of the specifics of this rule. New issues. New issues encompass all initial public offerings of equity securities sold under a registration statement or offering circular. However, the following securities are not considered new issues and may be sold to restricted persons. Secondary offerings. Private offerings, including securities sold under Regulations D and 144A. All debt offerings, including convertible and non-investment grade debt. Preferred stock and rights offerings. Investment company offerings. Exempt securities as defined by the Securities Act of 1933. Direct participation programs and REITs. Rights offerings, exchange offers, and offerings made under an M&A transaction. ADR offerings with a pre-existing market outside the U.S. Preconditions for sale. Before selling a new issue to any account, a firm must satisfy certain preconditions for sale. Prior to distributing shares of a new issue to an account, a firm must obtain a written representation from the account holder or any authorized party of the account, stating that the account is eligible to purchase new issues. This representation may take the form of an affirmative statement that clearly declares the account's eligibility. This information must be verified every 12 months. Prohibited sales. A firm or any person associated with a member firm is prohibited from offering or selling a new issue to any account in which a restricted person has a beneficial interest. Furthermore, a member firm or any person associated with a member firm may not purchase a new issue unless an exemption applies. Restricted persons. The following individuals are considered restricted persons: FINRA member firms and any associated person, i.e., employee of the member firm. An immediate family member of an employee of a member firm. Immediate family members include a spouse, parents, siblings, in-laws, and any other person materially supported by an employee of a member firm. Under the rule, aunts, uncles, and cousins are not regarded as immediate family members and are therefore not considered restricted persons. The previously listed immediate family members are only viewed as restricted persons if any one of the following three conditions applies. 1. The employee gives or receives material support to or from the immediate family member. Material support is defined as providing more than 25% of the person's income or living in the same household as the individual associated with the member firm. 2. The employee is employed by the member firm selling the new issue. 3. The employee can control the allocation of the new issue. For example, Mike is employed by ABC Investment Bank and supports his brother. Therefore, his brother is considered a restricted person. Another example, Keith is employed by NDK Investment Bank and his firm is the managing underwriter of Compaqo IPO. Consequently, Keith's immediate family members are restricted from purchasing any of the shares in the Compaqo IPO from NDK. Other restricted persons include finders and fiduciaries, such as attorneys and accountants involved in the offering of the new issue, and any person to whom they provide material support. Portfolio managers purchasing for their own account, including individuals who can buy or sell securities on behalf of institutional investors, as well as any person to whom they provide material support. These individuals are in a position to direct future business to the firm, which is why they have restricted status. It is important to remember that a portfolio manager is only considered a restricted person if she is purchasing an equity IPO for her personal account. There are no restrictions if she is purchasing shares for the fund that she manages. Persons who own a broker-dealer, including anyone who owns 10% or more of the firm. General exemptions. The new issue rule also provides several general exemptions. These exemptions allow a new issue to be sold to the following accounts: investment companies registered under the Investment Company Act of 1940, the general or separate account of an insurance company, a common trust fund, an account in which the beneficial interest of all restricted persons does not exceed 10% of the account. This is a de minimis exemption. Publicly traded entities other than a broker-dealer or its affiliates that engage in the public offering of new issues. Foreign investment companies, ERISA accounts, state and local benefit plans, and other tax-exempt plans under IRS Code 501(c)(3). Another exemption allows a broker-dealer to purchase shares of a new issue if the offering is undersubscribed. This means an underwriter can place shares in its own investment account as long as all public demand has been satisfied. However, an underwriter cannot sell shares of an undersubscribed issue to other restricted persons. Issuer-directed securities. SRO rules permit certain individuals related to the issuer to purchase shares of a new issue, provided the issuer specifically directs securities to them. The purchasers falling under this exemption include the parent company of an issuer, the subsidiary of an issuer, employees and directors of an issuer. This exemption allows a registered representative to purchase her employing broker-dealer's equity IPO shares or the shares of the parent or subsidiary. Other restricted persons may also purchase shares of a new issue, provided they are employees or directors of the issuer. To avoid overwhelming you with long videos, we'll keep it brief and easy to digest. Join us for a follow-up video where we will continue the discussion from this one. As always, please like this video so others can benefit as well. If you are a new viewer, we invite you to join our family with a free subscription.